Are you married to a United States citizen or a green card holder and planning to apply for a green card through marriage? If so, stop scrolling because what you're about to hear could determine whether your application is approved or whether you face denial, delays, and even deportation. Since President Trump returned to office in 2025, United States immigration policy has shifted dramatically, and marriage-based immigration is now under some of the strictest scrutiny we've ever seen. These aren't just rumors or political headlines. These are real policy changes already affecting thousands of couples across the country. In this video, I'll walk you through every major update you need to know, from new fraud detection protocols, updated forms, and more invasive interviews, to the increased risk of deportation, even while your application is pending. Traditionally, marriage to a United States citizen has been one of the most secure and direct paths to permanent residency. United States citizens could file Form 1130 to sponsor their spouse, and green card holders could also petition, although with longer wait times. But in 2025, that process has been turned on its head. Citing concerns about fraud and abuse, the Trump administration has directed USCIS to tighten the rules, expand investigations, and raise the standard of proof for marriage-based petitions. The result? More denials, more interviews, and far greater risks for couples, even genuine ones. One of the most significant changes is a new fraud detection protocol within USCIS. This isn't a vague, we're checking more carefully approach. It's a detailed mandatory checklist every USCIS officer must follow. They now review your complete immigration history, cross-check your social media accounts, compare timelines of your relationship and key events, and analyze your travel records and living arrangements. If anything appears inconsistent, such as marrying right after a visa overstay, not having joint finances, or showing gaps in your relationship timeline, your application can be flagged for deeper review or outright denial. The key difference in 2025 is that USCIS is starting with the assumption of fraud unless you prove otherwise. That's a massive shift in mindset. Perhaps the most alarming change is that USCIS now has the authority to start removal proceedings while your green card application is still pending. Before 2025, applicants married to U.S. citizens were generally safe from deportation unless they had serious criminal issues. Now, if you've overstayed a visa, made mistakes on your paperwork, or left out key documents, you could be placed into removal, even if you're legally married to a U.S. citizen. Simply filing an application no longer shields you from enforcement. In early 2025, USCIS revised major forms, including the I-130, I-485, and I-129F, without widespread public announcements. The new forms include more detailed background questions, stronger fraud warnings, and expanded sections on prior immigration history. Submitting an outdated version now leads to automatic rejection. Many couples have lost months because they unknowingly filed the wrong edition. Always check the edition date at the bottom of the form against the USCIS website before filing. Stokes interviews, which were once relatively rare, are now being used far more often. So here's how they work. Each spouse is questioned separately for an hour or more. Officers will ask extremely specific questions about your life together, like what side of the bed you sleep on, or even what you ate for dinner 3 nights ago. Then your answers are compared for consistency. Even real couples can struggle under this pressure, especially if they've been long distance or have cultural differences. Inconsistencies can result in denials or even fraud accusations. Previously, overstaying a visa could often be forgiven in marriage-based cases, particularly when the petitioner was a United States citizen. Not anymore. In the year 2025, overstays of more than 180 days can trigger a 3-year re-entry ban. Overstays over 1 year can trigger a 10-year ban. These bars apply even if you are married to a U.S. citizen unless you qualify for a hardship waiver, which is now honestly much harder to get. Hardship waivers are supposed to prevent families from being unfairly separated. But in 2025, USCIS has raised the bar significantly. You must now prove extreme hardship to your U.S. spouse with strong documented evidence like serious medical conditions, documented psychological trauma, or exceptional financial dependency. Simple letters or bank statements are no longer enough. Officers are looking for life-altering consequences, not just general inconvenience. If USCIS suspects your marriage is not genuine, the consequences are severe. A permanent ban from any U.S. immigration benefits, possible criminal charges with up to 5 years in prison, and a $250,000 fine. Even honest couples can get caught in this net if they don't provide enough evidence. Some lawmakers are, pushing back. 2 key bills in Congress could bring relief. The Dignity Act of 2025 would shorten wait times, create dual intent visas for spouses, and reduce family burdens. The American Families United Act would give judges more discretion to stop deportations in cases involving U.S. citizen spouses or children. So, however, neither bill has passed yet, which means, the current stricter rules are still in place. It's important to collect overwhelming evidence: photos, joint bank statements, leases, travel records, utility bills, text messages, and even affidavits from friends and family. Make sure to use the latest forms and always confirm the addition date on the USCIS website before you file. You might want to consider getting professional help. An experienced immigration attorney can, honestly, identify risks that you may overlook. Always be 100% honest. Never lie or coach your spouse with fake answers. If you don't remember something during an interview, it's totally fine to just say so. And apply early.